Thank you for that generous introduction. I'd also like to thank Raul Kerstocha, who was the person I think behind the invitation for me to come and speak to you this morning with the background to the conference, the seminar that you're organizing. I have also a very close connection, as the previous speaker mentioned, about me with the Memorial Museum, a major memorial museum in Romania, in Sighet, which was part funded when it was established in 1993 by the Council of Europe, and I was placed on the board of that museum. I was up at the museum in northern Transylvania in September of this year, and I saw that more than 60,000 visitors just this summer had visited the museum, many of them, in fact, school children. My own personal connection with the museum and with Romania's communist past stems from the fact that members of my wife's family were political prisoners in Romania during the communist period, and I also have an extensive file held by the Romanian secret police on me because of my activities in Romania in the 1970s and 1980s. So with that background, I'd like to proceed to my PowerPoint presentation, which I've given in order for you to have a record, of course, of what I said, but also perhaps to provide some comparative dimension to what has been happening in other countries in the former communist bloc of Eastern Europe. So as my second slide mentions, my presentation is really looking at taking a comparative approach to the issue of lustration. And lustration is the term generally applied to the cleansing of a previous regime. It was first used in recent terms in Czechoslovakia in the late 1980s. After the collapse of communism in Central and Eastern Europe in 1989 and 1990, all of these former communist states were faced with the problem of tackling the past, and different approaches were adopted. But in those approaches, the activities and files of the secret police were the main focus of attention. What I seek to do in my presentation is to give a digest of the way in which the legacy of the secret police was handled in several countries, first of all in Germany, and at the same time, through the prism of the German experience, we can formulate questions with regard to how this subject was tackled in Czechoslovakia, Poland, and Romania. Government policy towards historical archives can be seen as a barometer of commitment to transparency, and in post-totalitarian, totalitarian or repressive societies, public access to formally sealed historical archives has particular importance for creating a basis for the development of democracy. It can be argued that the opening up of archives in post-totalitarian societies fosters a sense of nationhood by permitting an examination of the abuses of the past and by encouraging the creation of safeguards, ensuring that those crimes are never repeated. Access to secret police files demonstrates three things, I think. First of all, the degree of intrusion of the state into the private life of the citizen. Secondly, it restores to history those whom the authorities sought to eradicate from public memory. And thirdly, it allows the distortion of the past practiced by regime historians to be challenged and corrected. But the opening of access to the files can also lead to what has been called memory wars. Memory wars is a term applied in psychological studies in the 1990s to the controversy between some clinicians and memory scientists about the reliability of memory. And the term is sometimes invoked by historians when analyzing the reception and interpretation of secret police files. In this reading, the secret police files in some former East European communist states, and in particular in Poland and Romania, have become suspect in the eyes of the public in respect of the reliability of their content and their political instrumentalization. Political sensitivity to the past is illustrated by the reluctance of authorities in several Latin American countries to declassify their secret police files. Nevertheless, in 2003, the work of compiling and classifying some 3.5 million pages of the records of the Intelligence Office of the Buenos Aires Provincial Police in Argentina began. Access to secret police files is the key to lustration. In general, lustration involves the screening of suspected individuals using secret police files to determine whether they had collaborated with the former state security service. Some lustration bills or laws targeted the whole network of former elite secret police and their collaborators, some only specific segments of the former regime. Here's a copy of a Czech lustration certificate, which was issued after the revolution after the fall of communism in Czechoslovakia. So I've just given that example of a form which shows that the person who is being investigated is not recorded, and their name is neither listed nor is there any number given in any archival forms to alleged collaboration with the Czech secret police at the time, the STB. It's significant to point out that unlike denazification in Germany after World War II, where the main driving engine for the policy of lustration was external, the driving force for, or indeed the greatest resistance to, in many of the former communist countries was an internal one. A Polish scholar, Natalia Lecki, argues that there are two internal driving forces in the former communist countries. They are public opinion and public support and demand for lustration, and secondly, political elites who should, in a democratic system, reflect the demands of the public. But what Lecki notes is that more often than not, public opinion supports lustration far more strongly than political elites do. Dealing with the communist past could become a tool in the struggle for political power and be exploited by some politicians to undermine their opponents, especially if former communists were able to reinvent themselves in the eyes of the public. And this is the view of Kieran Williams and colleagues in a publication of 2003, where he talks about the political vitality of lustration. And we've seen this evidence in several of the former communist states. When EU membership became an option, pressure was put on these former states as part of the accession process to lustrate to ensure democratic consolidation. Lustration, or the lack of it, is and was related to problems of corruption, and the lack of lustration and removal of communist-era officials enabled many of them to use or to convert their old political power into political and economic power today. And we can see that if we look at the background of many of the oligarchs in the former communist states in East Central Europe, to see where their money came from. And in fact, in many cases, it originated from their service in the security services of those communist states. Let's now turn to lustration in the German Democratic Republic. In the summer of 1990, the GDR parliament published or passed a law giving access to all citizens to their personal files. And then the German Bundestag, after reunification, adopted the law on the German Stasi files or East German Stasi files in December 1991. And this regulated the handling of the Stasi files. And the official title of that body is the Federal Authority for the Archives of the State Security Archives of the former GDR, often called the Gauck Commission after the name of the first director, Joachim Gauck. Its current federal commissioner is Roland Jahn. The commission controls the Stasi Records Agency, and the Stasi files run to 111 kilometers and are administered by a staff of 1,313 as of the 31st of December 2020. The law on the Stasi files gives three important reasons for opening the files. The first was that the victims of repression and surveillance must be offered the chance to clarify how the state intruded into their lives. The second was that state institutions and other bodies must be able to check whether their employees collaborated with the secret police. And the third was that the files represent an object of historical, political, and legal investigations. More than 1.9 million citizens applied by the end of 2001 for their access to their files. About 10,000 applications were launched every month, and these were requests from the individuals concerned, but not only from them, but also from institutions and researchers. The sense of relief was often accompanied by other feelings: disappointment and anger towards those who betrayed them, and horror at the extent of surveillance of them. And then finally, feelings of revenge, on the other hand, appeared to be extremely rare when we're looking at the legacy of access to the files. Moral rehabilitation is often more important than compensation. Victims are relieved and satisfied when an unjust sentence imposed in the GDR is officially annulled, and when their voice is heard by the competent state authorities or by the press in the United Germany, and when their suffering is recognized. After reunification, checks were made on public administration employees in Eastern Germany to see whether they had been members of the Stasi or collaborated with it. By the end of 2001, 1.6 million requests for verification have been submitted. 6 to 7% of those checks were revealed to have been Stasi officers, and the employer could decide whether to dismiss such persons. The decision was taken in respect of how long and how closely the officer or collaborator worked. The consequences were these: that in Berlin alone, the prosecutor's office dealt with 23,000 cases during the 1990s linked to so-called injustices committed in the GDR, that is, political motivated deeds. And these were concerned less with the illegal acts of the Stasi and more to the mistreatment of prisoners and fatal shootings on the border between the GDR and West Germany. Of the 23,000 cases, only 600 led to prosecution, and in the photograph you have the bodies of the sad victims of shooting by East German border guards of East German citizens who tried to scale the barbed wire covered wall between East and West Berlin. Of the 600 cases I mentioned, about 1,000 persons were brought before the courts. Of these, 1,335 were convicted. The sentences were in most cases light. Only 32 were sent to jail. Of the 600 prosecutions, only 69 were brought against former Stasi officers, of whom only one was sent to prison. The other Stasi officers either received lighter punishments or were acquitted. And these figures that I mentioned refer only to cases handled in Berlin. In the other East German Länder, the prosecutor's office dealt with similar cases. Many of the victims of the Stasi consider their treatment in the reunified Germany as unjust. They were discriminated against professionally. In many cases, they could not attend university, and thus they were at a disadvantage in the job market after 1990, in spite of their moral rehabilitation. The bar on retroactive punishment gave protection to those responsible for political repression in the former GDR. This stipulates that a deed can only be punished under the law if at the moment of its commitment it contravened existing laws. The only exceptions were serious infringements of human rights. In other words, after the collapse of the GDR, the law was only capable of punishing deeds which had broken GDR laws. The failure to punish meant that the hopes which the victims of the communist system in constitutional democracy were disappointed, and a pension for victims, a so-called pension of honor, was not introduced in Germany. Former Stasi officers and collaborators have profited from the new situation. They have managed through the courts to have their large pensions, which had been reduced in 1990, to be restored. And in tackling the abuses committed by the GDR regime, attention has been focused on the Stasi and not on those chiefly responsible for repression and political persecution, that is to say, the activists of the East German Communist Party. Here's a copy of an East German Communist Party party card. Confronting the past in Germany was approached on an administrative and legal basis, and this implies a degree of impersonality. Many people place too much hope in the extent to which the past would be assumed and reparation made. Erhard Neubert, a human rights activist in the GDR, a theologian and a member of the Gauck office, repeatedly warns of these overblown expectations. I quote from him, "The federal authority for the Stasi archives, that is the Gauck office, is not an authority on the truth. We do not administer the truth, only documents." West Germany then was an instigator of change in East Germany and financed it. At one stage, the Gauck office had a staff of 3,500. Currently, it's 1,300. In 1989, GDR citizens occupied the Stasi building in East Berlin and forced the abolition of the Ministry of State Security. They also confiscated the Stasi files, the bulk of the Stasi files. The Stasi did not have time to destroy the compromising files. The peaceful revolution in the GDR was also a revolution against the secret services. This fact is reflected in the law on the Stasi archives. According to paragraph 25, Stasi documents with information referring to the applicant or to a third party cannot be used by the intelligence agencies for them, that is the intelligence agencies post-1990. The law allows only for a few exceptions. In Romania, in the early 1990s, there were politically motivated leaks of state security files designed to compromise politicians. It was not until December 1999 that the law on the access to personal files and the disclosure of the Securitate as a political police was passed, and access to the Securitate files was regulated. Individuals have the right to consult any files held by the Securitate on them. Members of the Council for the Study of the Archive of the Securitate, which is composed of 11 members of Parliament drawn from various political parties, were given unfettered access to Securitate documents. The Council was empowered to verify, upon request from any Romanian citizen, whether a candidate or incumbent of a public office have been a member or informer of the Securitate. I ought to add here that the council hasn't been always able to do this because of the small number, barely 300 members of the council for the college for the study of the archives. They simply haven't had time or the personnel to verify the claims or the requests made by Romanian citizens to verify the past of those who are candidates or incumbents for public office in Romania. Under the law of 1999 in Romania, establishing the CNSAS, that is the National Council for the Study of the Securitate Archives, the Post-Communist Security Service, the SRI in Romania, was required to hand over custody of the Securitate files to the CNSAS. But the law did not give a deadline for this to take place, and consequently, it took a long time. In fact, it took until 2006 that the SRI, under pressure from the then president Traian Băsescu, announced that it was beginning the transfer of files to the CNSAS. However, the SRI refused the CNSAS's request for index to the files, thereby making the process for the SS or processing by the CNSAS painfully complicated. Any archivist will tell you that if he doesn't or she doesn't have access to an index, it makes life very difficult. But eventually, most of the files were handed over, and they total approximately 20 kilometers in length and are administered by approximately 300 staff. In the Czech Republic and Slovakia, the Czechoslovak lustration law was passed in 1990. It is the most radical example of lustration or decommunization, combining vetting and exclusion from certain public offices of both Secret Service officers and Communist Party officials. It forbade Communist Party functionaries from the district level upwards, from STB officers, residence agents, informers and candidates, and members of the party's Felicia from holding a range of public offices, some 9,000 of them until 1996. It did not, however, prevent them from standing re-elections, nor did it apply to former interior or justice ministers. Lustration was an unintended consequence of a commitment to a lawful transition, which foreclosed summary trials of high-ranking officials. As of October 1991, when the lustration law was passed, state attorneys had managed to indict only 12 STB officers using the laws in existence by 1989 and have won no convictions. Politicians therefore wanted a speedier non-criminal sanction, and STB officers therefore could not serve in the Post-Communist Security Service, the FBIS, if they had worked in counterintelligence directorates or commanded a whole department. Exemptions could be made by the FBIS director or Federal Interior Ministry. Holders or seekers of the offices in question had to apply to the Interior Ministry for a certificate confirming that they had no links to the SDP. The law was suspended in Slovakia after the 1st of January 1993, but extended in the Czech Republic to 2000 and then indefinitely. Many of the 80,000 candidates standing in local government elections in 1994 in the Czech Republic decided themselves to be lustrated, even though the law did not require it. And by 2002, more than 400,000 people have been screened, and 3% told that their names appeared in informal roles.
Dear Professor, can I, apologizing for the interruption, can I ask you to conclude, because we are running out of time and we have another keynote speaker. which do not have time.
Okay,
Yes.
all right. Okay, so I'll just come to my conclusion for you. You can find what else is in the PowerPoint, of course, which I've submitted to you. But my conclusion is a very simple one, and that is by not confronting the past, the society is effectively victimizing the victims of oppression. And here I quote the words of Archbishop Desmond Tutu, chairman of the Truth and Reconciliation Committee in South Africa, and spoken with reference to the excesses of apartheid. And he said, we should look the beast of oppression in the eye and stare him out, not allow him to pass unchallenged. And then finally, lustration is not designed to apportion guilt. It is conceived in order to attribute responsibility and to extract from the perpetrators of repression recognition of that responsibility. So thank you for your attention.
Thank you.